Hi, welcome to another episode of Around the Gavel. I'm your host, Sarah Morris, and today we're going to talk a little bit about quiet title actions. As you may or may not know, my firm practices in the area of estate planning, real estate, and business law. So quiet title actions are part of our repertoire. We file quite a lot of them. Uh, especially this year, actually, we filed more than we have in the past. So, to give you an idea, quiet title actions are needed when you've got basically a cloud on title. So, if you look at the chain of title for the property at issue, and there's some kind of problem, let's say there's an old lien that shouldn't be there anymore, or there's a lien that should have been removed but was never removed, or something like that, then many times you're going to have to actually file an action in court for quiet titles to clear the title so that title insurance will insure. Most of these things come up because a person goes to sell their property, and sometimes, like I have an example from yesterday. I had a potential client call me, and this is a very typical thing that happens. He has a property. He got into contract with a buyer, and he was ready to close. They go to the title company, and the title company explains to them that actually there's a problem with title, so they can't insure it. Because in his case, and this is a great example, he had a deed of trust on the chain of title that hadn't been reconveyed, that he thought was reconveyed and he thought should have been reconveyed. So there was this open deed of trust on the property that prevented him from closing on the deal. That's why he had to call me. So what we would have to do in that case, because in his case, a deed of trust is generally something that is recorded in the chain of title by a bank when you get a mortgage. In Nevada, if you have a mortgage on your property, then the bank is going to secure the mortgage by recording a deed of trust on the property. So in our PC example, he had a deed of trust recorded on the property that he thought shouldn't be there and was previously negotiated. In order to remove that from the chain of title, he's going to have to file a lawsuit. So, of course, this can be costly and take some time, but that's what we have to do if we want to clear the title. So that's just one example. Another example is if there's something wrong with the chain of title in terms of ownership. Like maybe there's some kind of a rogue deed where the property was deeded to somebody that wasn't actually, should not have been on the chain of title. So then you have to file suit and you name all the prior owners. That's more of a traditional quiet title action. You've got to name all the prior owners on title and try to clear it all out so that you can obtain title in your own name. So quiet title actions can take a long time or they can be very quick. It all depends on what the person that you're naming is going to do, and that's true for any litigation case. It all depends on if they're going to fight back or if they're going to just roll over or if you're going to get a default judgment against them. It all depends. Unfortunately, though, it is a necessity in many cases where you've got some kind of document on the chain of title that hasn't been cleared and the title company refuses to insure until that thing is taken care of. I could actually go on and on about this for an hour, but I'm not going to do that. I'm going to save you guys. I just wanted to jump on real quick and explain to you generally what a quiet title action is. As always, if you have a quiet title action or you have any questions regarding business, real estate, or estate planning, please feel free to call our firm. We do offer complimentary 15-minute phone consults, so you can at least figure out if you have something that you need an attorney to look at and how much it's going to cost. So that's it for this time. We'll talk to you next time. See you later.